Good morning, everybody. We'll just wait a moment or two as people enter in, but bonjour tout le monde. Nice to see everyone on day 2 of the Legacies of Patriation. So welcome from wherever you're tuning in. We have a leisurely mid-morning hello to Atlantic Canada and a very early morning hello to those of you in British Columbia. And for those who are elsewhere around the world, I suspect it's all manner of the time of day. So I'm glad that we're able to join together this morning. Hello. So my name is Eric Adams. I'm a law professor at the University of Alberta, Faculty of Law. I'm coming to you this morning from Treaty 6 territory and the Métis homeland, Edmonton, Alberta. And it's really my pleasure to be hosting this morning's keynote plenary address from a scholar I have long admired, and I'm excited to hear from this morning. I'll introduce him in a moment, but first, let me just say, as one of the conference organizers, how pleased we were with yesterday's sessions and events. I hope you found them as stimulating and exciting as we did, and we're looking forward to day 2. So we hope you're able to stay with us through the great sessions we have lined up for today. And no better way to start an exciting day than with an exciting talk. So let's get right to it. We have him for the next hour. There'll be a little time, I hope, at the end for some questions. So when it's time for me to come back, I'll be happy to moderate a few questions. As you know, you can put those into the chat. And let me introduce now our speaker, who is going to be known to so many of you as Professor Jean Leclair of the Université de Montreal, the Faculty de Droit. And Professor Leclair, as you know, has been one of Canada's leading thinkers and scholars in federalism, but also in the constitutional relationships between the Canadian state and Indigenous nations. For my money, he's one of the most elegant writers and beautiful thinkers in Canadian constitutional law. And so looking forward to his paper this morning, which has had a title change. It is called "Are Full-Blown Indigenous Legal Orders Now Constitutionally Guaranteed?" And with that, I'll turn the floor over to Professor Leclair. Jean?
Thank you very much, Eric. The admiration is mutual, by the way. Premièrement, je voudrais remercier les organisateurs de m'avoir invité à cette belle expérience. Et je vous parle de Montréal, un endroit où se sont croisés de multiples peuples autochtones, et entre autres la Confédération Haudenosaunee. Alors merci de bien vouloir m'écouter aujourd'hui. Zeus brooked no opposition. He was unwilling to share his absolute sovereignty over all living things. So when his first wife Métis, goddess of good counsel and wisdom, became pregnant with their first child, he feared she would bear him a son who might one day dethrone him. Well known for his cunning ways, Zeus devised the following plan. Since Métis was endowed with the power to change her appearance at will, he would suggest that they play a game. He first asked whether she could transform herself into a fire-breathing lion, which she did at once. He then inquired whether she was able to take on the form of a drop of water. Of course, she said. As soon as she was done, he swallowed her entirely. As anthropologist and historian Jean-Pierre Vernant summarizes the moral of this story, the great question of indivisible sovereignty was thus resolved. But although Zeus would remain the sole holder of the sovereign power, the tale does not end there. After swallowing Métis, the god of gods began to suffer from terrible headaches. Summoned to his bedside by his cries of pain, Prometheus and Hephaestus could find only one solution, and accordingly, they both seized an axe and violently hit Zeus's head with it. Under the blow, a fully armed Athena sprung out of Zeus's head, complete with her helmet, spear, shield, and bronze armor. From then on, she would make herself heard, and she would play a major role in the worlds of gods and men. In Sparrow, the very first case dealing with Section 35, the Supreme Court famously stated that, quote, "There was from the outset never any doubt that sovereignty and legislative power, and indeed the underlying title to all lands, vested in the Crown, unquote. Thus was claimed the absolute sovereignty of the Crown. By this simple utterance, all other possible claimants to sovereign power were thus swallowed. However, much water has flowed under the bridge since 1990, and political and legal headaches have set in. These headaches result from a radical transformation of the political dynamic between Indigenous and non-Indigenous peoples, the consequence, among others, of 4 commissions of inquiry, and from the unexpected consequences of jurisprudential and doctrinal interpretations of the Supreme Court's own theory of Aboriginal rights. In a paper presented in Alberta a few years ago, I argued that constitutional change is simultaneously driven by political action and by transformations in normative discourse. At the political level, as Professor Stephen Holmes puts it, quote, "If you wish a constitutional norm to govern the way politicians behave, you need to organize politically to give ruling groups an incentive to pay attention and accept the restraints on their own discretion for their benefit and yours," unquote. Moreover, constitutional change is made possible when this political action is combined with the mobilization of new and powerful normative discourses about limited government, democracy, liberty, and equality. In the constant struggle for constitutional change, the ideal feeds the real and the real feeds the ideal, in the sense that normative discourses provide the ideas around which non-elites can ally themselves with one another and with willing members of the elite, to exert on dominant political elites the pressure required for something like reconciliation to happen where Indigenous and non-Indigenous people are concerned. I also underlined that constitutional change is always, in part, the result of the unintended consequences of human actions and decisions. My thesis today is that this process of diffuse and reflexive constitutionalism has been happening for the last 30 years, and that it has now culminated in the recent Quebec Court of Appeal's decision in the reference to the Court of Appeal of Quebec in relation with the Act respecting First Nations, Inuit, and Métis children, youth, and families. In this reference, while the federal statute was held unconstitutional in part, a unanimous bench of 5 judges recognized that all Aboriginal peoples under Section 35 of the Constitution Act 1982 have a generic right to self-government concerning child and family services. Thus, all Indigenous communities are now better equipped to pursue the daunting but exciting task of establishing the institutions and processes that are central to vibrant contemporary Indigenous legal orders. It remains to be seen whether the Supreme Court will uphold the decision. Without going into the full details of the case, I will try to highlight some of its most essential features. While doing so, I will try to show that even if the court does not always express it in this fashion, a federal spirit underlies its reasoning. Federalism is built upon 2 main principles, autonomy and participation, guaranteed by a constitution. These 2 principles undergird the court's coherentist interpretation of the division of powers under the Constitution Act 1867 and Section 35 of the Constitution Act 1982. Another important overarching feature of the decision is that the court's interpretation of Section 35 is, I believe, based on both a subjective and an objective understanding of a right. The judges considered not only whether Indigenous peoples had a justifiable claim to self-government, a subjective collective right, but also, and more importantly, whether recognizing Indigenous self-government was the right thing to do, right in an objective sense, in light of the nation-to-nation relationships that have developed between Indigenous and non-Indigenous peoples over the centuries. The inquiry concerns what has to be recalibrated in this relationship for the entire system to remain legitimate in the eyes of all the constituent partners of the federal polity. 1. The right to self-government and Crown sovereignty. First, nowhere in this 570-paragraph decision is there any mention of the Sparrow quotation referred to above. Even though state sovereignty is at the heart of the dispute, and despite the Court of Appeal's recognition of both the federal and provincial government's power to limit, under the Sparrow test, Indigenous peoples' right to self-government. Clearly, the court wants to avoid approaching the problem as a clash of sovereignties. No mention is made, for instance, of the Haida Nation case, where the Supreme Court stated that treaties serve to reconcile pre-existing Aboriginal sovereignty with assumed Crown sovereignty. It is also notable, for instance, that the court never characterizes the Indigenous right to self-government as residual Aboriginal sovereignty, except in its description of American case law. It speaks instead, in less loaded terms, of a historical right of self-governance, or of the right of an Aboriginal people to govern its internal affairs. In other words, the Canadian state's sovereignty, understood as the power to enact laws that will prevail over any competing norms, unless constitutionally protected, and bind everyone, is not called into question by how the court defines the Indigenous right to self-government. Indeed, the court recognizes the validity of federal and provincial legislation imposing significant limits on the exercise of this right, subject to the Sparrow test. Although the court avoids any discussion of sovereignty understood in its legal jurisdictional dimension, its whole reasoning rests on a political understanding of sovereignty. That is, not simply as the expression of an official power belonging exclusively to a specific governmental entity, but as the product of a political relationship. As I will explain in a moment, the justices conceptualize sovereignty as a relational phenomenon. In this light, sovereignty is not a thing or a power that can be owned or exchanged. As one author puts it, quote, "In the relationship between ruler and ruled, sovereignty belongs to neither, but to the relationship itself," unquote. Therefore, rather than focusing on sovereignty as an expression of the state's absolute power to make law, the Court of Appeal apprehends it as an expression of the relationship between the Crown and the people, in this case, Indigenous peoples. In this perspective, conflicts of authority become something other than a zero-sum game. In the first place, the court resorts to Chief Justice Dixon and Justice Laforêt's rhetorical ploy in Sparrow, but in an entirely different manner. Instead of claiming that there was from the outset never any doubt that sovereignty and legislative power vested in the Crown, the Court of Appeal states that, quote, "It is no longer disputed that the Aboriginal peoples of Canada functioned independently from the Crown until sometime in the 19th century," unquote. It then goes on to place the political and legal relationships established between the Crown and Indigenous peoples since the conquest of 1760 at the center of its mammoth decision. Summing up its conclusions, the court states that, quote, "The historical relationship between the Crown and Aboriginal peoples, both before and after Constitution Act 1867, establishes that Aboriginal peoples have always been recognized as peoples and not merely as subjects, and that they continue to be governed by their own laws and customs in those areas of jurisdiction that do not conflict with the Crown's assertion of sovereignty, that have not been voluntarily surrendered by treaty, or that have not been extinguished by government," unquote. In support of its contention, the court also describes the many non-constitutional initiatives, most notably the 1995 Aboriginal Self-Government Policy, the 10 principles respecting the Government of Canada's relationship with Indigenous peoples from 2018, and the many self-government agreements the Crown and diverse First Nations and Inuit groups signed between 1973 and 2021, all of which were directed at recognizing that Indigenous peoples held a limited right of self-government. In view of these initiatives, the justices conclude that, quote, "The right to self-government, including in matters of child and family services, is not an entirely new political or legal subject. The concept, while admittedly not yet fully defined, has been percolating," says the court, "albeit quietly, for a number of decades under various aspects, sometimes even implicitly, and has carved a modest place for itself in the federal legislative landscape, particularly since 1995, transitioning from administrative autonomy to a somewhat political autonomy, although always within the context of Canadian sovereignty, unquote. To borrow an expression from Professor Robert Hamilton, it seems that whatever the subordinate status accorded to Indigenous peoples by the text of the Constitution Act 1867, a federal logic has characterized the interstitial changes that have taken place since Confederation. From its examination of the case law, the different policies adopted by the federal government, and the reports of many public inquiry commissions, the Court of Appeal concludes that the Crown has recognized Indigenous peoples as self-governing people, and more importantly, as founding partners of Canada. The justices added that, quote, Section 35 decisively altered the relational dynamic between Aboriginal peoples and the Crown by giving Aboriginal peoples a special status as distinct social and political actors within Canada, a status that they already held, but which was put on hold by the colonial assimilation policies implemented from the late 19th century until the third quarter of the 20th century, unquote. Therefore, the 5 justices implicitly reject a purely voluntaristic approach to federalism, one that emphasizes the existence of a sacred moment of explicit exchange of consent enshrined in a formal constitutional text. Instead, they embrace an organic conception of the Canadian federal order, which allows for the recognition of long overshadowed and neglected Indigenous constituent actors. By basing our federal order on pre-existing units of Indigenous self-government, on lived patterns of solidarity, by thus recognizing instead of denying the legitimacy of local authorities, the court actually reinforces the federal political community and the legitimacy of the state as a whole. In the words of Jeremy Weber, quote, a federal structure of government will be sustained as long as that balance corresponds roughly with our sense of lived solidarity, unquote. 2. A generic right to self-government in relation to child and family services. In Pamajiwan, the Supreme Court stated that, quote, Aboriginal rights, including any asserted right to self-government, must be looked at in light of the specific circumstances of each case, and in particular, in light of the specific history and culture of the Aboriginal group claiming the right, unquote. The Court of Appeal unshackled itself from this dictum by claiming, as Professor Brian Slattery suggested in his article, A Taxonomy of Aboriginal Rights, that Delgamuukw had modified the analytical framework developed in Vanderpeet, and that this adjustment opened the door to the recognition of a generic Indigenous right to self-government. As to the nature of such a generic right, the justices quote Professor Slattery at length, and I quote, generic rights are not only uniform in character, they are also universal in distribution. They make up a set of fundamental rights presumptively held by all Aboriginal groups in Canada. There is no need to prove in each case that a group has the right to conclude treaties with the Crown, to enjoy a customary legal system, to benefit from the honor of the Crown, to occupy its ancestral territory, to maintain the central attributes of its culture, or to govern itself under the Crown's protection. It is presumed that every Aboriginal group in Canada has these fundamental rights in the absence of valid legislation or treaty stipulations to the contrary, unquote. The justices also cite Professor Slattery's comment that, quote, the generic rights held by Aboriginal peoples resemble the set of constitutional rights vested in the provinces under the general provisions of the Constitution Act 1867, unquote. The reasoning and methodology followed by the Court of Appeal, in determining the existence of a right to self-government in relation to child and family services are akin to those applied by courts assessing the scope of a legislative power under Section 91 or 92 of the Constitution Act 1867. Like Professor Slattery, The court's approach is analytical, not empirical. Remarkably, the justices never refer to the need to link the claimed practice to a pre-contact behavior. Instead, they focus on American and Canadian case law and doctrinal analyses written over the last 30 years. These sources lead them to conclude that, quote, despite the federal government's assimilationist policy, Canadian courts have generally recognized Aboriginal customary law and, by inference, the right of Aboriginal peoples to govern themselves in certain fields of jurisdiction, unquote. In this light, the question then becomes not so much whether the claimed right relates to the pre-contact culture or way of life of an Indigenous society, but whether or not it is compatible with the Crown's assertion of sovereignty. This kind of question does not call for an examination of specific historical practices, but for an abstract normative analysis. The court, in the reference, eventually finds that Indigenous legislation of child and family services would not pose, quote, an existential threat to Canadian sovereignty or to the Canadian legal order, or being compatible with either of those, unquote. In addition to employing an analytical methodology, the court reframes the purpose of Section 35. Instead of focusing, as the Supreme Court generally does, on the need to reconcile Indigenous peoples' prior occupation of the territory with the Crown's assertion of sovereignty, emphasis is placed on ensuring the development and cultural survival of Indigenous peoples as distinct peoples. The court claims that Section 35 aims to provide, quote, a constitutional space for Aboriginal peoples so as to allow them to live as peoples with their own identities, cultures, and values within the Canadian framework, unquote. Nevertheless, the most groundbreaking dimension of the decision is that by recognizing a right to self-government, the court transforms Section 35 into a mechanism for institutional recognition, not simply a means of enshrining specific cultural practices. It is, in fact, recognizing a veritable power to make law. The justices admit as much when they refer to the, quote, generic right to regulate child and family services as a jurisdiction, compétence, essential to the cultural security and survival of each Aboriginal people, unquote. Or when they state that, quote, while there is a distinction between Aboriginal customary law and the right to regulate or modify that custom, the latter right is but one step removed, unquote. And the justices further assert, and as the justices further assert, an Indigenous right to self-government includes, quote, the freedom of Aboriginal persons as a group, community, or people to designate their governing bodies and regulate their own governance methods, unquote. Section 35, therefore, no longer provides merely for the constitutional entrenchment of specific activities, such as the right to hunt or fish. Why did the court not simply recognize an American-style residual Indigenous sovereignty? As I said earlier, I suspect that the court wanted to steer clear of any language associated with the notion of sovereignty. Remember that the justices do not question the superior status of either the federal and provincial governments, each standing above Indigenous peoples. Even the court's direct reference to Indigenous institutions was risky, since sovereignty is often equated with institutionalized public power. The justices might have thought it best to remain vague. As we say in French, glissez mortel, n'appuyez point. Moreover, recognizing a residual sovereign power to make law would have meant acknowledging the power of Indigenous institutions to adopt norms capable of binding non-members. By linking self-government to a collective right instead of a jurisdiction, an imperium, Indigenous peoples are allowed to govern the conduct of their members only, not that of all individuals within their territory. The court's tectonic normative shift has therefore not called into question the fundamental pillar of the positivist constitutional edifice, the sovereign power of the Crown. Still, the court's reasoning challenges for the first time the doctrine of discovery that currently denies rights to all Indigenous communities unable to meet the empirical tests developed by the Supreme Court to demonstrate the existence of an Aboriginal right or title. By acknowledging a historical right to self-government put on hold by colonial assimilation policies, the court confers legitimacy, if only indirectly, to all existing Indigenous lawmaking processes and authorities. In other words, Indigenous legal orders are now constitutionally recognized, at least in relation to matters of child and family services. Indigenous communities must now tackle the arduous task of maintaining and revitalizing those legal orders. More needs to be said about how the court envisages the Indigenous right to self-government in relation to child and family matters. A careful reading of the decision suggests that, in the court's view, Section 35 has a dual function. First, it guarantees Indigenous communities jurisdiction over family matters, that is, the power to make law in this area. If the right is deemed by a court of law to exist and not to be inconsistent with state sovereignty, then it is unassailable. At this first stage of the analysis, the Sparrow test does not apply. However, it comes into play at the second stage because the federal and provincial governments may restrict the specific norms adopted in the exercise of that jurisdiction within the limits established by the Sparrow test. In the reference, the court first holds that, quote, the regulation of child and family services is an existing Aboriginal right for the purposes of Section 35 of the Constitution Act 1982, and that it is a generic right that extends to all Aboriginal peoples, unquote. After this jurisdictional recognition, the justices go on to state that, quote, where there is a real conflict between Aboriginal and federal or provincial legislation, one must conclude that there is an infringement of the Aboriginal right. Since the Aboriginal right is recognized and affirmed by Section 35, the Aboriginal legislation must prevail, unquote. Section 35 thus provides a mixture of freedom to jurisdiction and freedom from protection against unjustified restrictions. 3. The benefits of institutional recognition. By confining Aboriginal rights to pre-Columbian cultural practices or land issues, the Supreme Court allowed Indigenous identity to be essentialized by all parties involved in the debate. In addition, instead of encouraging scholars to inquire into the nature of contemporary Indigenous lawmaking institutions and processes, the court's approach has resulted in most energies being channeled towards the search for Indigenous law in historical records, oral history, or the wisdom of elders. This work is undoubtedly important. However, it tends to confine Indigenous law to the realm of Platonic principles and values, to the detriment of contemporary actors and processes that are very diverse. Values, principles, and rules are not self-implementing. In all systems, institutions and processes are necessary for their application in practice. Focusing on values and principles also has the unfortunate consequence of marginalizing the issue of power. This is so because a discourse focused on values and principles always flirts with the transcendent, since it concerns ideals to which we aspire rather than prosaic details of our daily lives. At a theological level, all systems of regulation seek perfection. But inevitably, legal systems are concerned with the mundane world, marked by power relationships, where, whether we like it or not, de facto equality is nothing more than a pale reflection of ideal de jure equality. Certainly, some communities are more egalitarian than others, but that still does not mean that all their members are equal in status. For example, it is undeniable that customary or Indigenous legal systems often grant greater authority to older members than to younger generations. Whether this difference in status is considered legitimate changes nothing in the fact that the different groups do not exercise the same degree or intensity of power. By focusing too much on a legal system's primary rules, to speak in Hartian vocabulary. In other words, the rules under which human beings are required to do or abstain from certain actions, whether they wish to or not, one risks neglecting the secondary rules, those conferring legal powers to adjudicate or to legislate or to create or vary legal relations. However, it is these secondary rules of the systems, whether state or indigenous, that raise the issue of power, including the power to determine what constitutes law according to the system, rule of recognition, the power to govern the introduction of new primary rules to manage the life of the group, rule of change, and the power that enables certain people or groups of people to determine whether a primary rule has been transgressed, rule of adjudication. The power exercised by Indigenous public institutions, like that of their non-Indigenous equivalents, is not theirs alone. Rather, this power is entrusted to them by the political community holding the right to self-government. The relational nature of sovereignty applies equally to the exercise of non-Indigenous and Indigenous public power. Another benefit is that by officially recognizing that contemporary Indigenous public authorities have the power to make law, the Court of Appeal makes it clear that, quote, we must avoid reinforcing the idea that Aboriginal peoples are passive subjects of law, whom the federal and provincial governments can regulate according to their respective areas of jurisdiction as set out in sections 91 and 92 of the Constitution Act 1867, unquote. Recognizing that Indigenous authorities hold a limited right to self-government thus highlights the democratic agency and accountability associated with the exercise of public power. Finally, by recognizing a generic right to self-government, the Court of Appeal transforms Section 35 into a tool benefiting all communities, not just those with the means to mobilize the courts. And this recognition might deliver an electric shock to provincial governments, which have for the most part been passively waiting for individual communities to go to court before they pay any attention to their plight. 4. The challenges raised by this institutional recognition. As the Court of Appeal itself admits, acknowledging a right to self-government raises the question of, quote, which governing entity, governing body, can legitimately represent or act on behalf of an Aboriginal people in the exercise of its Aboriginal rights, unquote. And that, quote, it is conceivable that the act will lead to a certain fragmentation of Aboriginal governance, not only among potential competing governing bodies, but also among Aboriginal groups, communities, or peoples, thereby possibly muddling the relationship between them, or perhaps their relationship with the provinces, which may have to deal with a larger number of interested parties, unquote. Another possible challenge is a change in the political dynamics of multi-level Canadian Indigenous governance. Since 1982, pan-Indigenous institutions have been the leading spokesperson for Indigenous peoples. They have advocated for what is generally referred to as treaty federalism, that is, the negotiation of self-government agreements between the Crown and specific communities. The focus at the national and the local level has therefore been placed on executive-centered intergovernmental relations. Perhaps energies will now be directed elsewhere than toward the executive level, with maybe a preference for judicial forums and local political action, since communities are now encouraged to occupy the field of self-government by adopting their own constitutions and laws and lawmaking processes. Another benefit is that by redirecting attention away from pre-Columbian practices and land issues to lawmaking institutions, the recognition of the right to self-government also places the question of the legitimacy of Indigenous law at the heart of the analysis. The power of state and Indigenous agents alike has multiple sources of legitimacy, which have, however, sometimes in tension with each other. Input legitimacy, output legitimacy, rational legal legitimacy, charismatic legitimacy, symbolic legitimacy or legitimacy by shared beliefs, which itself comprises appeals to collective identity, spiritual beliefs, and tradition. All these are at play among Indigenous communities and will deserve attention. Finally, as mentioned earlier, the decision leaves open the question of who is bound by Indigenous law. 5. The intertwined destinies of Indigenous and non-Indigenous peoples. As I have mentioned, the Court of Appeal repeatedly says that both the federal and provincial governments may set reasonable limits on the rules and norms enacted in the exercise of an Indigenous right to self-government, as long as the Sparrow test is met. The right to self-government, said the court, is, quote, not an absolute or unlimited right, but it does indeed exist within the contemporary Canadian constitutional architecture, at least with respect to child and family services, unquote. The justices also say that Parliament's jurisdiction over under Section 9124 is very broad, allowing it to legislate in relation to family matters. They further observe that in Chilcotin and Grassy Narrows, the Supreme Court set aside the doctrine of interjurisdictional immunity with respect to Aboriginal and treaty rights, allowing for the application of provincial laws of general application that respected the regime established under Sparrow. Finally, they recall that in Daniels, the Supreme Court stated that federal jurisdiction over Indigenous peoples did not mean that all provincial legislation pertaining to Indigenous communities was inherently ultra-virus. Thus, the Court of Appeal recognized an extensive playing field within which both levels of government may legislate over Indigenous child and family matters. We may recall, however, that where there is an actual conflict between Aboriginal and federal or provincial legislation, the court finds that the Aboriginal legislation must prevail, since the Aboriginal right to self-government is recognized and affirmed by Section 35. Now, how can the recognition of an Aboriginal right to self-government be recognized with this generous interpretation of federal and provincial jurisdictions? According to the court, this situation flows from the, quote, relational dynamic, unquote, embedded in Section 35, in the Section 35 justification test, which, quotes, requires a reconciliation of Aboriginal and non-Aboriginal interests, quote, not an adversarial approach. The court, while acknowledging the need to recognize an Indigenous right to self-government, is nonetheless convinced of the need to integrate that right, quote, within the complex and interdependent political community in which they are exercised, unquote. Remember that Chief Justice Leclair stated in Gladstone, quote, distinctive Aboriginal societies exist within and are part of a broader social, political, and economic community over which the Crown is sovereign, and there are circumstances in which, in order to pursue objectives of compelling and substantial importance to the community as a whole, taking into account the fact that Aboriginal societies are a part of that community, some limitation of those rights will be justifiable, unquote. We must beware of conceiving of Indigenous communities as totally homogeneous and unanimous. It is more empirically accurate to understand Indigenous people as members of different overlapping communities where they can participate simultaneously but for different purposes. I surmise that this is also why the court concludes that, quote, as citizens of Canada, Aboriginal peoples are as much entitled to the protection and benefits of the rights and freedoms set out in the Charter as all other citizens, including protection against infringements by their own Aboriginal governments, unquote. And that, as Canadian citizens, they also, quote, are entitled to benefit from the services provided by the provinces with which the federal government must coordinate its efforts so as to take account of the particularities of Aboriginal peoples, unquote. Suppose one accepts the hypothesis of a federal spirit animating the court's reasoning. In that case, one could say that the court wants to combine the idea of Indigenous autonomy with the necessary participation of Indigenous communities in the development of federal and provincial standards that have the potential to restrict their rights. Moreover, the court does not want the federal and provincial governments to relinquish their responsibilities over the management of issues such as Indigenous child and family services. Instead, in this respect, the justices are convinced that, quote, cooperation between the federal and provincial governments in recognizing and implementing Aboriginal rights is necessary to ensure the harmonious exercise of these rights, unquote. Sixth, and finally, the issue of Indigenous paramountcy. Having found that there was such a thing as an Indigenous right to self-government in matters related to child and family services, the Court of Appeal concludes that Section 18 of the challenged statute was valid. This provision states, quote, that the inherent right of self-government recognized and affirmed by Section 35 includes jurisdiction in relation to child and family services, including legislative authority in relation to those services and authority to administer and enforce laws made under that legislative authority, unquote. Since the court finds the premise of the federal legislation to be true, the right to self-government does indeed exist in matters related to child and family services, Section 18 is therefore merely declaratory of the state of Canadian constitutional law as interpreted by the justices, and thus does not violate Section 35. As I mentioned in the introduction, the court nevertheless holds Section 21 of the Act to be unconstitutional. That provision states that an Indigenous law enacted in conformity with the Act has, quote, during the period that the law is in force, the force of law as federal law, unquote. It also declared the unconstitutionality of subsection 22(3), which says that in the event of a conflict between such an Indigenous law and a provision respecting child and family services in a provincial act, the former prevails to the extent of the conflict or inconsistency. Before examining the court's argument, I wish to stress two things. First, as we've seen, the court believes that Section 35 already provides the proper basis for Indigenous paramountcy. Second, given that conclusion, the justices made it clear that, in their opinion, the challenged sections were unnecessary. They wrote, quote, if, as Parliament asserts in Section 18 of the Act, self-government is an existing Aboriginal right recognized and affirmed by Section 35, would this in itself result in some form of paramountcy for Aboriginal laws? If so, Section 20 to 22 of the Act could not bar such paramountcy. Be that as it may, the court found it necessary to declare Section 21 and 22 unconstitutional. Recall that Section 21 of the Act confers the force of law as federal law on Indigenous legislation enacted according to Section 20, according to the Act. Now, according to the court, the doctrine of federal paramountcy, quote, which underlies the constitutional architecture of sections 91 and 92, does not allow the federal government to grant that same constitutional priority to the legislation of an Indigenous governing body, acting pursuant to an Aboriginal right of self-government. Indeed, it only pertains to federal legislation validly enacted in a field of federal jurisdiction. It pertains to sections 91 and 92, not Section 35. Hence, according to the court, the section is unconstitutional because the laws adopted by the Indigenous governing body are not federal laws enacted under Section 91, but rather Aboriginal laws that serve Aboriginal imperatives. It seems that this argument confuses jurisdiction with the fruit of its exercise. Section 18 is a declaratory provision recognizing a generic right to self-government in child and family services. As for Section 21, it is concerned with the Indigenous laws enacted in the exercise of that generic right. It aims to give them the authority of federal law. Section 21, therefore, does not extend the application of the doctrine of federal paramountcy to an Aboriginal right, but to the norms resulting from the exercise of that right. I do not see how this indirect incorporation of Indigenous laws is unconstitutional, since the federal government could easily adopt them piecemeal as they arise without violating Section 9124. the justices also declared Section 22(3) unconstitutional. This provision states that in the event of a conflict between an Indigenous law enacted in conformity with the Act and a valid provincial law, the former prevails to the extent of the conflict or inconsistency. The court reached this conclusion on the ground that, with this provision, quote, Parliament has elevated the Aboriginal right to regulate child and family services to the status of an absolute right, at least with respect to provincial legislation. In so doing, it has amended the purpose and scope of Section 35, which are grounded in principles of mutual respect and reconciliation, unquote. Again, I do not find this conclusion entirely convincing. I admit that subsection 22(3) must not dictate to courts how to determine when federal paramountcy should be triggered. For example, this section must not be interpreted as requiring courts to rely on a generous conception of conflict, the occupied field theory, rather than a restrictive notion, the operational conflict theory. Such an interpretation would lead a court to conclude that the pith and substance of the provision is the interpretation to be given to the constitutional principle of federal paramountcy, which is an undoubtedly unconstitutional purpose. However, in the context of the reference, through the operation of Section 21 and 22, the federal government is attempting to confer precedence over provincial laws, of Indigenous laws that it could have adopted piecemeal. It is true that through the operation of these two provisions, an Indigenous law may prevail over a provincial law, not as an Indigenous norm, but as a federal one, and that it can thus escape the Sparrow test. But is this an unconstitutional approach? Can regular legislation not provide greater protection than the Constitution? No one would deny that provincial human rights statutes often provide more efficient and less expensive means of protection than the Charter. Is that unconstitutional? I repeat, Parliament is not acting unconstitutionally. It is merely incorporating norms that it could enact itself. Section 88 of the Indian Act provides a good example. Basically, this atrociously abstruse provision establishes that provincial laws of general application that would be otherwise inapplicable are held to be applicable to and in respect of Indians in the province. The provision, however, specifies that these provincial laws are applicable, quote, subject, among other things, to the terms of any treaty. The text is clear. Once a more than negligible infringement of a treaty right has been demonstrated, the shield of Section 88 comes into play, and the treaty must prevail. There is no opportunity for Parliament to justify the infringement of the treaty right under the Sparrow test. In sum, treaty rights receive greater protection under Section 88 than they do from the test developed by the Supreme Court under Section 35. Although Chief Justice Leclair flirted with the idea that an implied justification stage might exist in the application of Section 88, the court later rejected this proposition. So a mere statute, valid under the division of powers, can sometimes provide a more robust shield for Indigenous peoples and citizens in general than the Constitution itself. I therefore remain unconvinced that Section 21 and 22 are unconstitutional. In truth, I believe Section 21 is essential because, as noted earlier, an Indigenous law adopted pursuant to an Aboriginal right of self-government is not directly enforceable against third parties. This difficulty falls away once the Indigenous law is given the status of federal law. In conclusion, it could be argued that the Court of Appeal has gone beyond what stare decisis allows. However, I believe that by abandoning ab-originalism, to use John Burroughs' fine expression, in favor of an approach emphasizing institutional recognition, the court has not only acknowledged the necessary role of Indigenous legal orders in matters of child and family services, but it has done so in a way that may enhance rather than undermine the Canadian state's legitimacy. More needs to be done before we can speak of the recognition of full-blown Indigenous legal orders. For this to happen, Indigenous peoples themselves must wholeheartedly embrace the task of maintaining and revitalizing their lawmaking institutions and processes. And as the Court of Appeal stresses, this will require funding. As Edmund Burke famously said, the revenue of the state is the state. The same goes for Indigenous governance. If Athena is to be a formidable opponent, she must wield a sword wrought from material more robust than bronze. Thank you very much for your attention.
I can guarantee, Jean, that if we were in person, you would be hearing a thunderous applause for that beautiful, elegant, thoughtful, really rich presentation that, for my money, gave me a page full of questions. So I'll give a moment here and let people say that you can type a question into the chat. There's a question and answer on the side there. We do have about 10 minutes, and so I'll endeavor to get to a few of them. Probably won't get to all of them, but this is a thoughtful talk for, I think, reflection in the months, probably years to come. But maybe, Jean, I'll start you off with something that you mentioned the Court of Appeal was keen to do, which was avoid the clash of sovereignties, certainly linguistically, in their framing. But of course, that can only be avoided for so long, and maybe ultimately the court's own legitimacy to rule on things like justified infringements brings to bear questions of sovereignty that can't be avoided. So if we're heading into a world, and I hope we are, where courts are able to recognize the rights of self-government on a more generic basis for Indigenous peoples, how will they tackle the sovereignty questions at the heart of who will be judging those conflicts and who will judge justified interference? And how does the Crown maintain a sovereignty to interfere at all if their sovereignty over Indigenous peoples has never been judicially or sanctioned constitutionally? Do you have any thoughts on that?
Well, if I understood the question well, I would say that I think that the court, through the decisions like that one from the Court of Appeal, I think is trying to generate its own sovereignty, as allowing for the participation, as an instrument for allowing for the participation of Indigenous peoples in the construction of the federal state comprised of Indigenous nations. Certainly, I would not see a court denying its own legitimacy or that of the state that created it. I mean, if you look at comparative constitutional law, you'll never see a court do that. But I think that the court is very much concerned about its own legitimacy. For instance, in the Supreme Court reference on secession, I think that the court was very much concerned about maintaining its own legitimacy in the eyes of Canadians and didn't give the federal government the answer it wanted. I think that's part of the answer to the secession reference. And I think that the court is going to do the same thing. It makes, courts make things up as they go, but they cannot escape recognizing Indigenous nations as political entities. I mean, they can't go back to, it would make no sense to ask a community to go to court and say that they had marriage rules. I mean, that would be insanely grotesque. And the court doesn't want to go there. So as concerns their internal affairs, I think the court would be very liberal in recognizing self-government. I don't know if that answers your question.
Yeah, no, thank you, Sean, for that. Maybe I'll ask one further question that came to mind for me, which is, and I see it's also in the one of our questions in the chat. So, do you foresee a future of recognizing governance rights tied to land or territory? Or do you think that this new logic is going to extend to areas of jurisdiction that are not territorially based? And how will the court navigate claims from Indigenous peoples, which are not going to be limited to areas of jurisdiction, but rather land base or the governance of a people, full stop?
Well, the advantage for the Court of Appeal in this case is that it was a non-territorial issue. So these rules adopted by Indigenous communities could apply everywhere. Let's start with the less problematic issue of hunting and fishing. I think there will come a day, well, where courts will recognize a universal generic right to hunt and fish. I mean, it makes no sense to ask Indigenous people to go to court and say that before we were here, they were fishing and hunting. This makes absolutely no sense. And so I think one day this position will be taken, and what will have to be negotiated is where can you fish, and quotas and everything. But I think that we're going towards this in over issues of hunting and fishing. Now, where title is concerned, well, basically, you know, it's the same kind of logic. I mean, the title was Indigenous prior to arrival. And so I know I don't have divine powers, but it seems to me that probably the big questions now will be questions of extinguishment, question of because of colonization, occupation of territory, of cities, and also the displacement of communities who had their title, their original territory somewhere and were displaced by colonization. I think we'll move on to negotiating these sort of things, because we can't keep on with the Vanderpeet test. I think there's a limit, and I think that hopefully one day the inherent limit that Justice Leclair just made up in Delgamuukw, and that is still maintained by the court in Chilcotin, will be dropped. I mean, this idea of there's something, you know, it's a white person who's going to decide what is an inherent right to the development of an Aboriginal title of land, and I think that won't stand for long.
That leads to maybe my last question, which is, if there is, and I think there is, as you've argued, there has to be this inherent right. There has always been an inherent right to govern. Surely that is also, if there's an inherent right to make law, there's an inherent right to also create legal processes within that community to review, as you say, the rules of order and the constitutionalism of its own legal order on its own terms, without recourse to the Quebec Court of Appeal or the Supreme Court of Canada. And how will courts be able to respond, or can they respond to kind of parallel judicial processes?
Well, for the first part of your question, I think the Wet'suwet'en crisis was a constitutional Wet'suwet'en crisis of constitutional Wet'suwet'en law. And I think that brings to the fore the question I raised about what is the source of legitimacy. If you recognize only legitimacy on the basis of tradition, charisma, and spiritual beliefs, then you will say, well, the elders, the traditional chiefs have all the right. But if you admit the equal validity of input legitimacy, elections, or output legitimacy, the fact that what a band council produces as a result is satisfying, well, then you have a clash of legitimacies, and that's normal. That's part of our game. You know, Montesquieu would say, where there's no conflict, there's no liberty. So there is conflict between Indigenous peoples, because like us, they're free, and so the question is, how are these questions going to be resolved? Will governments give preference to one segment of the community. So I think one of the big challenge, and in Quebec, we've been discussing about our own identity since 1760. And so I understand that it's not an easy task, but Indigenous communities themselves will have to determine how to create institutions to resolve these difficulties within themselves. And this is going, and I look at, I've studied environmental protocols developed unilaterally by First Nations. I've studied 23 of them, and it's fascinating. It's fascinating to see what kind of institutions are set up, how they mobilize oral tradition, how they mobilize history, how they mobilize international law, how they mobilize Section 35, and the kind of processes they ask of promoters, and then they contractualize these protocols. And so they can go to court and actually, through contractualization, see that their own laws are forced upon the promoters. So there are great ways for First Nations and other communities are very imaginative. And we must, I believe, focus on that real imagination going on through creating these contemporary lawmaking institutions and processes that feed on oral history, that feed on what the elders have to do, but sometimes end up being hybrid institutions that have legitimacy for the Indigenous peoples themselves.
Thank you so much. Maybe that's the perfect place to end things. The imaginative capacity of Indigenous legal orders and maybe the imaginative capacity of constitutional law to, as you say, find sovereignty in relationships. There may be real hope there. So thank you, Jean. You didn't see them because they were in the private chat, but what I saw was an overwhelming a sense of gratitude for your remarks from all kinds of people sending their thanks for that elegant talk. It's been a wonderful way to start the day. So thank you to Professor Leclair, and to all of you out there. Thank you for joining us this morning. We hope you'll continue with us through the rest of the day. And now would be a second round of thunderous applause, which Jean, I will let you hear from me. So merci beaucoup. And to all, see you at 9:15. Thanks again.
Okay, thank you very much, Eric. And like the two birds behind me, we have with this sun. Let's lift off for greater solutions. Thanks. Thank you very much.
Okay, à bientôt.